Hello, welcome to the Legislative Report. I'm State Representative Kate Harper of the 61st District in Montgomery County, and I recently took part in a joint hearing of the House Transportation and Judiciary Committees. The subject was the prevention and prosecution of impaired driving due to the use and abuse of drugs or alcohol. Repeatedly arresting an addicted person for DUI, only to see them reoffend and drive again, is not the best way to help them or to keep our streets safe. At this hearing, we heard the perspective of judges, law enforcement, and medical professionals on what does and does not work and the importance of treatment for the offenders. I'd like to share portions of the hearing with you now. I hope you find it informative as I did.
I thank you for the opportunity to address this panel regarding the ever-increasing wave of drug driving. There are no coincidences that other panels, both in the Senate and the House, are addressing at the same time the deadly heroin epidemic, as well as issues surrounding medical marijuana. There is a direct correlation between the deadly, predictable epidemic and this issue. First, let me share with the panel of my background from where I speak. I presently serve as the chairman of the National Drug Courts. I'm also the chairman of the State DUI Oversight Committee, looking at cases that go through the judicial process and the failures in regard to some of the treatment and some of the aspects surrounding it. And I also serve PennDOT as the Pennsylvania Judicial Outreach. I was formerly the DA for 3 terms in Lackawanna County and had the privilege of working in this building as an assistant DA for a number of years. While the issue of drug driving may seem as an emergent issue, it is not a new one, nor is it one that cannot be prevented. However, in all my years as DA and judge, I've never seen this tragic, widespread, and deadly. There are several issues that I believe are being worked on by the Department of Drug and Alcohol, as well as PennDOT and the state legislature regarding prescription abuse and now medical marijuana. As I am sure each one of you are aware, while the United States has approximately 4% of the world's population, over 80% of all the opioid use is here in the U.S. However, the studies of drivers under the influence of marijuana is a more recent and less studied problem. A recent survey that came out yesterday from the National Center of State Courts reports a Colorado study that shows that more young adults, 2 years out of school and older, are driving with people under the influence of marijuana rather than alcohol. Obviously, from our past, it's a huge change in regard to what people are driving, under what influence they're driving. Since 1980, MAD helped lift public awareness to the dangers of DUI, and that was viewed as an alcohol-only related problem. It was not even until 2015 that even MAD changed its mission statement to include help fight drug driving. In fact, here in Pennsylvania, the 2015 PA Crash Fact and Statistics looking at fatal crashes in Pennsylvania looked at alcohol-related, but has no mention whatsoever of drug driving or polyuse, the combination of drug and alcohol. Yet PennDOT and AOPC data clearly shows the rapid increase in DUI-D, meaning driving under the influence of drugs. The reality is that the presence of drug, illegal or legal, is more prevalent than the finding of only alcohol. While it may be understudied in academia and science, unfortunately has been well established in courtrooms and cemeteries across this Commonwealth. It is well established that the victim and the families of those killed that drug driving is no different than drunk driving, and that the criminal justice system and the legislature need to do more. I am sure each one of you are aware of the statewide numbers for arrest and conviction. I'm not going to go through all of them, except to say that there's a dramatic increase. As you've been made aware, law enforcement can inexpensively test for individuals' BAC, determine the amount of alcohol in the individual's system, and the presumptive level of impaired driving. That is not as easily done for drugs. Compounding the present problem, some counties and agencies, once they find that sufficient alcohol is present to prosecute, never bother to see if drugs are on board. Other counties have policies in place to detect if drugs are in the person's system if the BAC is a low tier. Counties like York, and here today you have present the judge who was really responsible for probably the best program, not only in Pennsylvania, but the country, and that's Judge Jack Kennedy and Lancaster, have absolutely seen a doubling in the number of drug driving cases over the last 6 years as a result of their proactive efforts to detect drugs. In neighboring Montgomery County, they have seen an increase in drug driving convictions while DUI convictions remain the same. The number of alcohol-related convictions over these years have decreased. The number of DUI have remained constant, but that DUI is now the drug driving. In my county of Lackawanna, while the arrest and conviction numbers are similar to those I just mentioned, there is also another shocking statistic, which is in the last 4 years, while 17 people have died in a substance abuse death crash, 16 of those deaths involved either drugs or drugs and alcohol. Only one of them was alcohol-only related. Recently in our county, a defendant pled guilty to homicide by motor vehicle for the death of a passenger in their car on Route 81 under Xanax and heroin. The following week, a 30-year-old woman was sentenced for 3 DUI drug driving over a 6-month period. And that's going to get to a second part, and I know that Judge Kennedy is going to talk about the efforts that he and your county made in regard to addressing the people that have been arrested in a second and third time before their first conviction is ever completed. This woman's third DUI while driving under prescribed Xanax and Percocet, she struck a crossing guard and a young student who suffered contusions and brain bleeds and broke 2 arms. The blood draw on the defendant showed not only the Xanax was in a toxic level, the pill count indicated that she should have had 168 pills and only had 30 at the time. We see the destruction. The question is, where do we go? This legislature has passed per se laws dealing with those individuals who have illegal substances while driving. For those drugs, as well as the legal prescriptions, the courts have to ensure that law enforcement has probable cause to detain and arrest these individuals. The officers need sufficient training and testing equipment so that the arrest will survive the court challenges. To this end, the individual police departments often say they lack the funding to send their officers for the requisite DRE training, especially in regard to the salaries for those officers that are missing on the street in their own towns. There must be adequate funding for these programs if the qualified individuals are to testify. The courts cannot blindly accept testimony without adequate training. As was mentioned earlier, testing for BAC is not difficult or expensive. The same does not hold true for testing of drugs. If the Commonwealth plans to seriously address this issue, drug driving, then adequate procedures and funding for chemical testing must be complete. As you're aware, the Supreme Court recently ruled in Birchfield that it cannot increase criminal penalties in regard to those individuals refusing to test or to be tested. Law enforcement needs greater legislation in regard to the issuing of search warrants that deemed necessary for the courts. The issue of arrest, though, in due process is a primary issue. And what I really would like to talk just a minute about today is the second one, what occurs after a conviction. If adequate treatment level of care is not mandated for those convicted of drug driving, law enforcement efforts will be futile, catch and release results. The arrest and conviction should serve as a therapeutic intervention to ensure that these individuals receive the proper drug and alcohol treatment they need to ensure they are not back behind the wheel of a car drugged driving. We cannot imprison our way out of this problem. Besides arming law enforcement with the tools they need, we need to ensure that the proper level of care treatment is mandated on these individuals. DUI courts and drug courts have proved to be effective tools in reducing recidivism. We need to make sure that the DUI courts and the drug courts are the systems that are supplied with the resources they need so that recidivism is reduced. Whatever measures the legislature looks to do combating drug driving, DUI and drug courts, with an emphasis on treatment and a defender being held accountable for their treatment, must be addressed if you truly intend to stop these preventable tragedies. I want to thank you for your time, and I really am open to any questions you may have.
Representative Harper.
Thank you for your testimony, Judge. From your vantage point, do you see a conflict between better enforcement of drug driving laws
and the move to decriminalize small amounts of, say, marijuana and things like that? Is there a conflict there?
I really don't see a conflict for two reasons. Alcohol by itself is legal. Medical marijuana in of itself is legal. Xanax and other medications are illegal. The question is the use and driving. And then the other part, obviously, is a substance use disorder. If the person has that substance use disorder and it's not being treated and they're driving and they're not being accountable for their actions, that's where I think the conflict comes in for the courts in regard to saying what is our role. There's four reasons for sentencing. One is punitive, just to take it out. The second is to make sure a person's incapacitated. And the other is, in regard to DUI, has always been to deter both that individual and others. But the fourth has been rehabilitation, and it's not been worked on. So the conflict that the court that often has is we see mandated sentencing. We see sentencing guidelines that basically say, what is the prior record score? What is the offense gravity score of this? Look, see what the mandatory time is, and we never look at the individual and the underlying problems. And so that's where the conflict really comes in for the courts. The arrest, I often look at the arrest as a healthy time. Arrest means stop, to intervene in that person's substance use disorder and to protect the people on the streets. And that's really what we as a court need to be looking at, not what's done beforehand.
Thank you very much.
If you ever want a perspective on these issues, Mike Barrace is a nationally renowned expert in these areas. I consider him to be one of my mentors, even though he came on the bench a little bit after me. I'm one of 7 regional judicial outreach liaisons for the National Highway Traffic Safety Administration. So both Mike and I get a perspective of these issues, not just in Pennsylvania, but across the nation. We've seen programs that work in various parts of the country. It is a significant issue, driving under the influence. I can tell you in Pennsylvania, most jurisdictions, most counties will tell you about a third of their criminal caseload are driving under the influence cases. And the unique thing about driving under the influence, in reference to Ms. McClinton's question, what I've found, and I've handled mental health treatment courts, I've handled drug treatment courts, I've handled DUI treatment courts, I've handled veterans treatment courts. In the DUI treatment court, particularly when you get your hardcore alcoholic, the attitude is, I don't have a problem, you got a problem with my drinking. Frankly, with the heroin addict and some of the other addicts, it's, I got a problem, I may not always want the help, but they'll at least admit they have a problem. The other thing about DUI that I think you have to put in perspective is, number one, in this country, if you're going to be killed by a stranger, it's probably going to be by a drunk driver. And the other thing about DUI is it's the one crime that you really can't protect yourself against. If you're concerned about burglaries, robberies, et cetera, there are things you can do for your personal safety. DUI tonight at 4:30 to 6:30, 7:30, you're driving home. There isn't anything you can do to keep that drunk driver from coming across the road and killing you. Now, in Pennsylvania, you can pat yourselves on the back a little bit. We are one of 4 states in the country who had a decrease in highway deaths last year. Most of the other states in the country are seeing increases. But what I really want to talk to you about today is the process of what I call catch and release. Mike talked about that a little bit with the rehabilitation process. But he also mentioned to you about the woman in his jurisdiction who had 3 DUIs, relatively short period of time, and our third one resulted in fatalities. We noticed that same issue in Pennsylvania and in York County. And it's not just a Pennsylvania issue. It happens across the country. Statistics show that an individual, a repeat offender particularly, who's been arrested for a DUI, let's say January 1, and doesn't get to court until April, statistics show nationwide that about 25% of those folks will get caught again. And when I say caught again, that's because they drive many, many times before they actually get caught. And to give you a little idea as to why, I think Mike would agree with me. Most of our repeat DUI offenders, what we see, we generally 50 to 60% of a combination of drugs and alcohol, but we see BACs that are far above the 0.16 limit. We see BACs generally in the 2s, sometimes the 3s. I've seen them as high as 0.54. Gentleman, Mr. English, raised the issue about the young man, 19, with several public drunkenness cases. I had a young man before me, 19 years old, .396. It was his first DUI. 3 previous public drunkenness cases. And because of Pennsylvania state law, which says that a first offense DUI is only punishable by 6 months, I really couldn't do any effective treatment. You need to have jurisdiction over someone for at least 2 years to have effective treatment. And as we all know, the criteria in the state to get to that third tier is .16. I don't think most people realize how drunk you are at .16. For me to get to a .16, I have to drink a fifth of liquor in 4 hours. I can't do that. Most social drinkers could not do that. So that's how intoxicated somebody is at .16. If somebody can do that, what that tells me is that they are drinking to excess several times a week at least, and they need an intervention. So that's one thing that I want you to understand. The other issue is really what happens now in Pennsylvania in majority jurisdictions. There are a couple other counties other than York and Lancaster that handle things the same way we do. But what happens in the majority of your counties if you're stopped in Pennsylvania, and let's say you've had 4 prior DUIs in your record. Police officer stops you, your blood alcohol is taken some way, either by breath or by blood, and you're back out in the street the next day without any bail conditions, without any significant intervention, and charges may not actually be filed. If a jurisdiction is using blood to determine the blood alcohol level, charges might not actually be filed for months. That's why we changed our system in York County. We realized that that was happening, and that when people were stopped, they would be taken to the hospital, the blood would be drawn, it would be sent out of town to determine what the BAC result was, and we weren't getting the results back for 6 to 8 weeks. And what happened then was the hospital would mail the results to the police department. If the officer happened to be off on vacation or wasn't around, then he'd type up the report when he got around to it. And we were literally seeing someone who would get arrested in August and wouldn't have charges filed till November. That is still occurring in the majority of jurisdictions in Pennsylvania. It still happens in the majority of jurisdictions across the country. What we did was we changed our system so that now when a police officer stops somebody, they are, I can't say required, but they're told that they're to run the individual's criminal record. And if it is a second or third offense DUI or 4th, 5th, 6th, whatever, then they are taken to see a district justice that evening. And within about 6 days, we start to do alcohol monitoring. And we also impose bail conditions that require a drug and alcohol evaluation. Essentially, what should happen in all DUI cases, and really what should happen in all criminal cases, is the first question the police officer has to ask is, who do I have and what do they need? And what you're seeing across the country in jurisdictions that are doing it correctly is, frankly, police officers are doing that in all cases. They're doing it to make a decision, number one, whether the person even needs to be detained, because there are all sorts of issues surrounding that, but particularly with DUIs. When you have a second offender, and the statistics are out there, you know that that individual is going to repeat that offense within a couple of weeks. There has to be an intervention. If you don't do that, they're dangerous. Every jurisdiction that has adopted that policy, frankly, we call it 24/7 monitoring. And there are all sorts of devices that you can use to do that. Ignition interlock is one. You can use ignition interlock to do 24/7. You can use, in York County, we use a bracelet that's made by his company. That works. In South Dakota, what they do is they require individuals to go to a police station twice a day and blow into a breathalyzer. Every jurisdiction that has adopted that type of policy sees about a 50% drop in victim compensation. In other words, the amount of money that's paid out to victims decreases by 50%. So that's how effective these programs are. The other thing that's happened in York County is it allows us to evaluate these individuals very quickly to determine whether or not they should be in a DUI treatment court. And frankly, I believe it's one reason our DUI treatment court in York County is so successful. Since 2010, we've had over 260 graduates. We've only had 11 of those people be arrested again for a DUI. When I was trained initially, I went down to Athens, Georgia. Mike Barace was one of my trainers. The other judge who was down there was Kent Lawrence, who's just a terrific judge from Georgia. And I remember him saying, You know, I take a 12th offender into my DUI court. I'm thinking, are you nuts? Why are you doing that? And here in Pennsylvania, we can't take people into DUI courts if they're a 4th offender or a 5th offender. Now, let me ask you, who needs the rehabilitation more, the 4th DUI offender or the 2nd DUI offender? Obviously, it's the 4th or the 5th or the 6th or whatever. But I'm thinking, you know, Kent Lawrence must be crazy. These people ought to be locked up forever. Number one, you can't do that. But what he said is, for public safety purposes, if we don't address the underlying problem, that person's going to get out and they're going to reoffend. Right now in Pennsylvania, anybody that's convicted of a 4th, 5th, or subsequent after that generally goes to the state prison. Over 99% of those folks go to the state prison. If they're released from state prison onto a state parole caseload, their risk or their chance of reoffending is 60, 70, 80%. Whereas you put them through a DUI court and you're talking less than 4% or less than 5%. DUI courts, drug courts are effective. Their recidivism rate's about 14%. DUI courts knock them out of the park. We're generally much lower than what the drug courts are. The other issue in Pennsylvania is when you ship them upstate, they come back into my community and they're placed on a state parole caseload. And let me tell you, state parole caseloads are overwhelming. Those officers have a high caseload. They see somebody with a DUI, that person's not going to get any amount of time compared to the robber or the rapist or any of the other dangerous folks that are on state parole caseloads. There isn't going to be any real emphasis to make certain they complete treatment. There's going to be very little drug and alcohol testing. What I've done and what York County has started to do, instead of sending folks to the state prison for DUIs, we keep them in our county prison. We allow them to work on the outmate program. And then we have put some of them into our DUI treatment court. And then we can make certain that they get the type of treatment that they need. And we've had a lot of success with that. So that's pretty much what I wanted to say.
Thank you, Judge. I'm pleased to submit to you the following testimony in support of pretrial bail programs like Target 25 in York County and the DUI repeat offender program known as DROP in Lancaster County. As you heard from Judge Kennedy, repeat DUI offenders are a serious concern, and York County statistics are not an anomaly. Once counties dig into their data, they too will likely discover they have a problem with repeat DUI offenders rearrested while out on bail. York County proves that bail conditions require sobriety and monitoring for it to work. The use of continuous alcohol monitoring devices that test for the consumption of alcohol every 30 minutes, 48 times per day, is an effective tool at reducing the incidence of people who are charged with repeat offense of driving under the influence. This continuous alcohol monitoring technology can and should be used in conjunction with ignition interlock devices, as they are both effective tools to reduce the incidence of impaired driving. However, little, if any, monitoring of these offenders takes place while they're on bail. Although the continuous alcohol monitoring device does not stop the car from driving, it does deter the behavior of drinking. Nationally, 99.3% of SCRAM days are sober days, meaning there are no confirmed drinking or circumvention events. When people are sober, they are not committing a driving under the influence offense. There is published research to support the aforementioned data. A study conducted by the National Center of State Courts examined the effects of SCRAM bracelets on criminal recidivism. Flango and Cheeseman compared rearrest rates for 144 offenders who were placed on SCRAM to those comparable offenders who were not placed on SCRAM. The groups were matched carefully by age, race, gender, county of residence, number of prior DUI offenses, and number of any prior offenses. The researchers found that only 3% of offenders on SCRAM recidivated while they were wearing the device, and repeat DUI offenders who were put on SCRAM for at least 90 days recidivated at half the rate of those not placed on SCRAM. As a lifelong resident of Philadelphia and Bucks County, Pennsylvania, I applaud you for considering replicating Target 25 throughout the state. Such legislation will improve the safety of our roadways for all of us in Pennsylvania, and I thank you for your time.
So, Judge, your program in York County and Lancaster County has been very successful, and we commend you for that. Have you shared your programs with other judges across the Commonwealth?
Across the Commonwealth?
Yes.
I have. I've presented at the State Trial Judges Conference in Pennsylvania.
So why have any of them have duplicated your program and your efforts?
I know Lancaster County
Right.
essentially has, and frankly, I believe that was instituted because there was a lot of publicity when I think it was a third or fourth offender ran through a red light and killed a family, and there were concerns with that. I will say I've always been fortunate in New York. When we have decided to do something, we've been able to get a consensus, and what we did when we started the program was we pulled all the players together, the sheriff's office, the clerk of courts, the prison, the treatment providers, the probation department. I mean, for lack of a better, it really took a village. And, I probably sounded more and more like a liberal Democrat, but I'm really a conservative Republican. Now that I'm not on the bench, I can say those things. But, the bottom line is it really, if you can get the folks together, it works. The biggest issue that we would hear is, well, how do you afford this? The average DUI offender in York County is a 35-year-old white male who's making approximately $40,000 a year. Most of your DUI offenders are working, and frankly, what we found is most of these folks were spending $60, $70 a week on alcohol. And I can't tell you, after we started this program, even the folks that didn't get into DUI court, how many people would come in at sentencing and tell me how much better their lives were now that they finally had become sober. I heard, I had my child's first birthday where I was sober. This has happened, that has happened. And frankly, it's forced sobriety, but that's what a lot of these folks need.
Well, that's all the time we have for today's program. I'm State Representative Kate Harper. If you need assistance with any state government matter, please feel free to contact me at my local office. The address and number will be shown in just a moment. Thanks for watching, and please join me again for Legislative Report.